Good afternoon, everyone. My name is Chris Morgan, attorney at Barran Liebman down in Portland. Thanks for joining us today. The last couple times we've talked, we've gone over risk mitigation strategies for keeping our workplaces compliant with state and federal guidelines, as well as also doing well and doing right by our employees. Today we're going to focus on 8 hot topic questions that I've been getting over the last several months from employers of all sizes related to COVID-19. With the evolving situation in our workplaces and with some counties in phase 1 or phase 2, and again, a fluid situation where we could be going back and forth at any time, I wanted to come in and address just a handful of the key questions that we've been getting over the last several months. We're going to focus on real factual scenarios that have been brought to our attention and to hopefully give you some strategies on how to mitigate risk in your workplaces and to address these situations. All right, question number 1. I have a policy requiring all of my employees to sign in when they arrive at the office. I ask that they take their temperature and attest that they are not experiencing symptoms of COVID-19. Am I allowed to do this? And if so, what do I do with an employee who refuses to sign? So a handful of key considerations here, and I'll try and give you the short of it when I can. Unfortunately, with some of these questions, it's going to take some explaining and some additional context. But the baseline answer to your question here is yes. So long as you are doing it correctly, asking the right questions and not asking for too detailed of information, you can absolutely have, and I would recommend that you have, a sign-in sheet for employees who are coming into the office. If they are able to attest that they've taken their temperature over the last 45 minutes to an hour and can attest that that temperature is 100.3 degrees or below, they can simply affirm that on the sheet. If not, I'd recommend getting a temperature taker that's reusable. They're not super expensive. You can get them on Amazon, among other places, for $50 or $60, and they can be reused. You'd also recommend, to the extent that you're reusing them, that employees wipe them down with disinfectants after their use as well. But employees would just simply scan their forehead, or at least this is the form of temperature taking that I would recommend. What we don't want to do, right, is having people taking their temperatures in their mouth or something like that and reusing that. That's not what I'm saying is okay. What we want to do is usually do a forehead scanner, and we want them to attest that they're 100.3 degrees or below. And then on the sign-in form, you're also going to have them attest that they're not experiencing any of the significant symptoms of COVID. Now, the difficult part with that is that the list of symptoms seems to be evolving over time, and we don't need to capture anything and everything, right? We're talking about fever, cough, shortness of breath. Now, a prevalent one is loss of taste or smell. And then the employee simply attests, dates the form, and then everyone's on with their day. Now, if an employee refuses to sign, what do I do? Right? It's all good if everyone's sort of compliant, and at the end of the day, that's what we want. We want employees to be following what we say and following our guidelines for a safe workplace. However, if an employee refuses to sign, simply put, you need to send them home. Because, and this goes back to some of what we talked about previously and in other sessions, with the fact that I don't want you to have a policy in place if you're not going to follow your own policy. And it certainly wouldn't go over well with the rest of the team if they're following the policies and you have an employee who is saying, I'm not doing it, but I'm coming into work anyways. The policy essentially has to be, if you're not willing to sign in a test that you're not experiencing symptoms and that your temperature is below that certain degree, we need to start looking at other things that we can do to accommodate them. That's not saying, hey, you're going home to work to do nothing. Step 2 from there would probably be, okay, well, to the extent that you can perform work remotely, let's have you go home and work remotely. Now, if that goes on for a prolonged period of time and it's 8-9 months down the road and this person is still refusing to come into the office and you need them to come back in, that's a situation that can be addressed a little bit later on. But for the interim, you're going to want to send them home, and you're going to want to see, okay, what telework, remote type of accommodation can we put in place to allow this person to still perform the essential functions of their position while not compromising the health and safety of the workplace? All right, question number 2. An employee of mine previously tested positive for COVID-19. His work performance has been deteriorating for several months, and I want to terminate him. Can I? This is an extremely common employment law related question, right? This comes up, of course, in the context of COVID-19, but it's come up for years prior with respect to, hey, I got an employee who has some sort of medical situation and might be entitled to some statutory leave under the ADA or FEMLA or OFLA, but they're not a good employee and they're not doing their job. What do I do about it? And that's one of the most difficult lines to toe, really, as an employer, is where do I draw the line between protected leave and otherwise upholding performance and conduct related standards. And so under this situation specifically related to COVID-19, you're going to want to do what you would otherwise do under any other circumstance when dealing with a medical related issue, right? So if someone says, hey, I have COVID-19 and I'm fine now, but I'm working remotely for a period of time, not because I haven't recovered, not because I don't feel fine, but I'm not quite comfortable coming into the office yet. What you want to do is just go back through and document the performance-related issues, treat it like any other situation, but be careful. So if, for example, someone had a medical-related issue and you come and say, Chris, I want to terminate this person, and I say, well, why do you want to terminate them? And you say, well, they have a history of performance-related issues. And I say, well, do you have that documented, right? How long has this been persisting? Have you worked with this person to improve their performance? Have you put them on a performance improvement plan, a PIP, as sort of a preliminary step towards termination so that we can say on the back end that we've given this person an opportunity to improve their performance and they have it? Right? Same sort of situation here. If you want to terminate someone, you can terminate them, but again, my question is going to be, what substantive documentation do you have to back up these performance issues, and have you sort of looked at some of these alternative means of disciplinary action, like a performance improvement plan, like deciding to further track productivity or whatever the issue is, so that we can hopefully address it without you being put in a position where you're terminating them, which could ultimately serve as an adverse employment action that gives them a cause of action down the road to sue you for whatever it might be. So go through your normal processes, treat it like any other request for accommodation, right? Think, does this implicate the ADA? Does this implicate FEMLA or OFLA? At this juncture? If it's someone who had COVID-19 that's now recovered, probably not, but right, think through some of these statutory basis for why this person would otherwise be entitled to leave prior to making that adverse employment decision. All right, our third question. An employee of mine believes that they may have recently been exposed to COVID-19 when out to dinner at a restaurant. She's decided to self-quarantine for 14 days and has asked me to pay her for that time pursuant to the Families First Coronavirus Response Act, the FFCRA. Do I have to pay? This is a really good question in a situation, frankly, that's coming up more often than you may think. And what you have to go back to, right, are the qualifying reasons for FFCRA. There's very sort of vague language in there regarding self-isolation orders and quarantine and things like that, right? Essentially under the FFCRA, a qualifying reason that would entitle them to paid leave is if a medical provider has asked them to self-quarantine, right? So the distinction here is really who is administering or asking for the employee to self-quarantine. Because in one scenario, if I go to my doctor and say, hey, I was out at this restaurant, there was a COVID outbreak there, I think I should quarantine for 14 days, doctor is probably going to say, hey, yeah, that's a good idea. At which point, when you ask the employee that question, they're able to say, hey, yeah, I went to my doctor and this is what he said. He said that I should self-quarantine for 14 days. Then the answer most likely is that yes, you would want to pay them pursuant to the FFCRA for that time that they're home self-quarantining. Now, if it was a different situation where they say, hey, yeah, I was at this restaurant and there was no sort of COVID outbreak or anything that I was aware of, but I hadn't been to a restaurant in 5 months and I just want to be careful and I don't think I have it, I'm not experiencing any symptoms, but I just want to stay home. That's a different scenario because that likely is not going to be a qualifying reason for that employee to be taking leave. So whether or not you have to pay under this particular instance is going to be dependent upon the specific circumstances that this employee is coming to you and saying, hey, I got to be home for 14 days. Is it because doctor ordered her to be home for 14 days? Or is it because they want to stay home for 14 days for some other independent reason? And after you get through that inquiry, you want to look at other things too, right? Does this person have a separate qualifying reason to be staying home under the FFCRA, such as they need to stay home to take care of a child, right? So go through sort of those 6 qualifying reasons under the FFCRA, and if none of them fit your circumstance, you don't need to pay the employee under that circumstance. All right, question 4. One of my employees has been working remotely for the last 4 months. His performance and productivity has suffered greatly. Can I require him to come back into the office? And if not, how do I address those performance deficiencies? This is another really good question, and it's going to be dependent ultimately on a handful of different factors, right? In terms of performance deficiency, we can always address performance deficiencies, but whether or not we're allowed to force them back into the office under the circumstances is a different question, and I think we really have to look at this question through the lens of, okay, what is the safest route for me to take under these circumstances? And really, with respect to all these questions, the safest route is always going to be accommodation. Accommodate to the extent possible. If there is a solution that doesn't force us to tell this person, hey, you need to get back into the office on Monday, that's almost always the route that we're going to want to take because it's the safest route from a risk mitigation and legal standpoint. So here, right, we want to look at, 1, what phase am I in, right? Depending upon the county that you're in the state of Oregon, you may be in a different reopening phase, and each of those phases allow different reentry into the workplace. So am I in a phase 2 where I'm allowed to bring employees back into the office at sort of a greater rate and with less issue than I would be if I was in a phase 1 county? That's a consideration, right? Because that bears on really how pushy I can be in terms of getting employees back into the office if I think they need to be more productive. Number 2, we got to look at the essential functions of the employee's position, right? Because what we don't have to do under any of the guidelines really is to say, hey, I have to continue to keep this person employed even though they're not allowed to come back into the office for whatever reason, and they can't otherwise perform the essential functions of their position remotely. Because the reality of it is there's plenty of businesses out there that there's no place for telework or for any sort of remote productivity to take place. So what does this person do for the essential functions of their position, right? And are they allowed to work remotely? Now, say for the purposes of this argument that they are allowed to work remotely and that your issue really insularly is just with their productivity. Hey, maybe they would be more productive if they were back into the office, but they can technically perform their job remotely. Now, if that's the case, you're probably going to want to allow them to continue to work remotely. I do think that one of the riskiest things any employer can do right now is to force employees back into the office before they're ready or take adverse action against them for saying, hey, I'm not coming back in, turn around and fire them. Probably not a good look, right? So for purposes of this question, I think what you want to do is focus more on the performance deficiencies and how can I fix this? Is there a way that I can still continue to allow the remote work while simultaneously addressing the performance deficiencies? And that's easy. Hop on a Zoom call, go through your normal HR processes, whatever they may be for addressing performance deficiencies, right? I think some of what we've seen is concern about a lack of productivity from remote employees, which is understandable, but we can address that over the phone, over Zoom, etc. The expectations aren't ultimately going to change. If I'm going to put someone on a performance improvement plan and say, hey, look, your sales have been down 60% over the last 4 months. What's going on here? We can address that and say, look, we're putting you on a 2-month employee improvement plan, and we want to see you pick it up a little bit. There are ways to quantify and measure that productivity remotely, right? So we're getting the same message across to the employee, but we're not forcing them to come back into the office. So that's really where I want you to go as a first step, is say, hey, can we allow this accommodation and address this performance deficiency at the very same time? And most of the time, what you're going to find is that you can. And if at the end of that, the employee's performance continues to suffer, say I get to the end of that 60-day performance improvement plan period, and this person still isn't doing what they need to do, then we can talk about maybe what are some other options here. Do we need to at least offer, say, hey, maybe you'd be more productive if you come into the office? Those conversations can be had as a secondary step. But what I want you to do right off the bat is to be accommodating while also addressing these performance improvement plans and these deficiencies through a remote means to the extent that you can. Question 5. In June, I had to lay off almost all of my employees. We are preparing to reopen, and I would like to rehire as much of my workforce as possible. Upon rehire, do I need to reinstate all of my employees' paid vacation time? What about their paid sick time under Oregon law? So that's a good question, and really the answer is dependent upon those two things. What time is considered employee paid sick leave that's been accrued under Oregon law, and what is considered independent paid vacation time? And that can get complicated sometimes, because so long as an employer is meeting their obligations to provide 40 hours under Oregon sick time, it's totally fine to have sort of a single bank that accounts for both vacation time and paid sick leave under Oregon law. But the distinction, and really where the answer to this question comes from, is that vacation time, and this is probably the easiest way to think about it, vacation time is a matter of company policy, right? Time that's accrued and available under Oregon law is not a matter of company policy. An employee is entitled to that time. Anything that you provide above and beyond that is really a matter of agreement between you, the employer, and the employee. So as a hypothetical example, say that I, as a company, allow 14 days of vacation time every year on top of the 5 days that are allowed under Oregon sick leave law. Say I front load all of it, right? And for purposes of my policy, I say, hey, we are not going to be paying out accrued but unused vacation time upon termination. Then in this scenario where you're essentially terminating these employees, you have no obligation to reinstate that paid vacation time if you were to rehire them, right? But here's the twist on that with respect to Oregon sick leave time, and where employers can get in trouble if they're not paying attention. Under Oregon law, in the event that you rehire someone within 6 months, 180 days, any time that they had accrued, any Oregon sick leave time, not vacation, Oregon sick leave time that they had accrued, that you did not pay out upon that separation, they're entitled to have that time reinstated back into their leave banks upon rehire. Now, employers under that scenario, so talking just for a moment on the Oregon sick leave time, you're going to have two options, right? So back in June, when this person had to lay off almost all of their employees, at that time they have two options with respect to Oregon sick leave. You can either pay it out, in which case, if you were to rehire within 180 days, you do not need to reinstate that because you already paid it out, and that person just begins accruing again from there, right? Or you cannot pay it out, but in the event that you rehire within 180 days, you need to reinstate that leave bank at the same level that it was at the time of separation, okay? And then with respect to vacation time, again, independent of that, above and beyond what the person might otherwise be entitled to under Oregon sick leave laws, that is a matter of your policy. So if you happen to have a policy that says, hey, 14 days in the event that there is a global pandemic and we need to lay you off and we rehire you within 3 months, we're going to reinstate all of whatever your vacation leave balance was, right? Well, if that's what you told them and that's what happens, then that person is likely going to be entitled to reinstation of that time. Now, the more common scenario, right, is either you have a policy that you pay it out or you don't. So in the event that you have a policy that says I will pay it out, and that person has 10 days of accrued but unused vacation time at the time of separation, you're going to need to pay that out along with the person's final paycheck. Very strict final paycheck laws here in Oregon. We're going to want to make sure that if there's additional benefit payouts that are triggered, in addition to any wages that they're owed, right, we want to ensure that to the extent you're saying, hey, we're going to pay out that unused vacation time at separation, that we're paying that out along with that final paycheck. Now, if we do that, of course, once we rehire, if we've already paid out the time, the vacation time, we're not going to have a duty to suddenly reinstate that vacation time. So it's very important to draw a distinction between time that's accrued under Oregon sick leave laws and then the separate vacation time, which is simply a matter of policy between the employer and the employee. All right, question 6. I have an employee who previously contracted COVID-19 in July of this year. Since then, and despite no longer exhibiting any symptoms, the employee is requested to work remotely. I would prefer for her to be in the office. Can I require her to come back and work from the office? Now, similar to what we talked about a little bit ago, we're going to want to err almost always on the side of accommodation. To the extent that there's any way that we can continue to allow this person to work from home, we should probably do it. At least for the time being, we really should probably do it. And again, I'm looking at this, and you should too, through the lens of what presents the least amount of risk to my organization, right? I'm trying to keep you essentially from getting sued, right? That's what this is all about. And so the safest way to do this is if there is any way that we can continue to allow this person to work remotely and work from home, that we accommodate that, irrespective of whether or not there's some statutory reason that would entitle them to such an accommodation. But similar to any other circumstance where someone says, hey, I'd like a remote accommodation, a telework accommodation as a result of some medical related injury or condition, we're going to want to go through sort of our checklist and say, hey, where am I at with respect to the state's guidelines? Am I in phase 1? Am I in phase 2 that allows some, more integration back into the office workplace? And 2, is this person allowed to perform their job remotely? Based upon the essential functions of their position, is telework feasible and allowed under the circumstances? Because if we're in phase 1, for example, to the extent that that person is allowed to telework, it doesn't matter whether or not they're no longer exhibiting symptoms, right? We're going to want to allow that telework accommodation regardless. So we got to look at what phase are you in your individual business with respect to state guidelines, and then does the essential functions of this particular person's position allow them to work remotely? And if the answer is yes, almost always, and again, for the time being, we're going to want to allow that accommodation. Question 7. An employee of mine who has been working in the office recently tested positive for COVID-19. He claims that he got it from being at work and has requested to file a workers' compensation claim. We have very strict safety protocols in place, and I have no independent reason to believe that the employee contracted COVID-19 at work. How should I respond? So this is probably the most simple question that we're going to cover today, right? And the answer is that you should respond as you would with any other employee who comes to you asking to file a workers' compensation claim. This is the same with litigation, right? It's the time to fight about the rights and the wrongs and the compensability and the non-compensability is later down the road and for someone else to do, right? We don't want, as an employer, ever to go to an employee and say, you know what, that's not a compensable workers' compensation claim. It very well might not be, right? But that's not our job. Our job is to take every potential claim seriously, right? And to go through the normal process. So when we're talking about a Form 801 and all of these things for sort of initiating this workers' compensation process, we want to go through our normal protocols no matter whether the claim is legit or we don't think the claim is legit, doesn't matter. Go through your normal protocols, be sort of, understanding of what they're saying and treat it like everything else. So go through your normal processes, and then that determination of whether it's legit and whether it's compensable as a workers' comp injury, that will be for someone else to handle later down the line. All right, our last question today, question 8. I have multiple employees who are unable to come into work as a result of their children's school closures and lack of available childcare. They're not able to perform their jobs remotely. What do I do? Do I have to pay them while they stay home? This is a really good question, and one that's coming up all the time, right? With school starting up this fall, some schools are open in a limited capacity and then they're closing, and there's a lot of fluidity in the situation, right? And most people are engaging in some form of remote learning. And so what an employer needs to do under these circumstances, we talked a little bit about the FFCRA, the Families First Coronavirus Response Act, but if there's one thing I want you to take away, right, when we're hearing child school closures and an accommodation for something related to childcare, I want you to immediately think of the FFCRA, right, the Families First Coronavirus Response Act, because likely this may be triggered, right? This may be triggered under these circumstances. So I want you to go through the list of qualifying reasons under the FFCRA and then determine whether or not the circumstance that the employee is presenting to you qualifies under the FFCRA. So if the employee is unable to work remote, because as we recall from prior sessions, if an employee is able to work remote, then they're likely not entitled to paid leave under the FFCRA because they'll be expected to work at home. But if the employee is not able to perform their job remotely, and they're not able to come into work because of a child care related reason such as a school closure, the person is almost certainly going to be entitled to some sort of paid leave under the FFCRA because it's a qualifying reason under the FFCRA. Now that doesn't mean that they're going to be able to get paid forever, because as we also recall, there's caps on the amount of hours for these qualifying reasons and caps on the amount of money that a company ultimately has to pay out. But even if it becomes unpaid leave at a certain point with the expansion of FEMLA, in the sense that we've added school closures and some related issues as qualifying reasons for leave under FEMLA, it very well may be that the person has qualifying paid leave for a period of time and then transitions to a qualified unpaid leave under the same statute for a period of time. So you're going to want to carefully look at the language of the FFCRA, keeping in mind that it very well may be a qualifying reason under there. And then as a secondary step, you'll want to keep track of how much time goes by, because it's very possible that the amount of time that you're going to pay them for that qualifying reason is going to be capped, and that the employee would transition to an unpaid leave, which would also carry with it some statutory job protections as well. So you'll want to look hard at the FFCRA to determine whether or not they can be paid, and then how long that employee is going to be paid under these particular circumstances. All right, everyone, thanks again for joining us. We've gone through 8 of the top questions that we've been receiving from employers, and I hope that some of the information that I was able to provide today was helpful to you. Again, we're looking at this whole thing through the lens of risk mitigation in terms of being compliant in our workplaces, but also doing right by our employees as well. Thanks, everyone. Take care, and we'll talk with you soon.